that is Navigating a Safe Harbour, Developing Immunity from Marital Rape. A warm welcome to the panelists. Just give a cheer as soon as I announce your names. Aarti Munkar, a lawyer. Veena Satyanarayan, Professor of Clinical Psychology at NIMHANS. Sneha Vishaka, Research Fellow at the Vidhi Center, and being moderated by Ravi Chandar, who wears many hats, but here he's the Honorary Director of Bangalore Literature Festival. So over to you all.
So today's session is about navigating marital rape immunity, finding a safe harbor. And this becomes relevant because there is a case in the Delhi High Court which is being discussed right now. And the idea really was to try and explore the myriad issues. It's pretty complicated. It's not as simple as maybe a group of activists may say, just get it out of the IPC in terms of the exemption. Another group will say, keep it in. So I think what we're going to do over the next 45 minutes is to get a sense of what are the various angles involved when we talk about marital rape, immunity for marital rape, and thereon. So just some background context. So there is the IPC section 375, which basically deals with rape per se, but it has something called the marital rape exemption. What we have called the immunity is the exemption, MRE. And the MRE says that in a marriage, there is really no concept of rape as far as the law is concerned. So hence you have the marital rape exemption. And a group of petitioners have gone to challenge, saying that this needs to go and the exemption needs to go, and section 375 should have none of these exemptions. So this has actually, I think there's an RIT foundation, which the case is in Delhi High Court. And then there's a government, there's also the Men's Welfare Association. I think that's the defendants in this case, which are saying it must stay. So we're going to try and understand the nuances of everything that's involved out here and deconstruct, because it's complex in the sense that at the heart, there are women who are involved. There are families that are involved. There is the parliament, which is supposed to make laws. There is the judiciary, which is supposed to interpret laws and intervene. And there's also the issue whether some aspects are judicial overreach or not. So before I get to the discussing the detailed aspects and before we get lost in the weeds of law, because that's why I separated the two lawyers, Sneha and Aarti, with Dr. Veena in the center. Veena, I want to start with you. You are a professional counselor. A lot of these ladies come to you who are in abusive relationships and the like. Give us a sense in terms of what's happening with these women. What is this trauma doing to them? So let's just understand the human nature of the problem before we go to what is it that the law says and why does the law say what it says. Veena.
Thank you so much. It's a pleasure to be here. Thank you for giving me the opportunity. I'm coming to BIC after a long time. And I'm sure all of you will agree that since the start of today, we've been receiving a lot of messages, celebratory messages, glorified messages about womanhood. Sadly, in my routine practice, I don't see too much of it. So the pertinent question about what this trauma does to women, I think I just want to emphasize a few points. Any kind of abuse leaves lasting impressions. These women typically may not always develop diagnosable psychiatric conditions like anxiety, depression, PTSD that we speak of, but the psychological impact of trauma itself is fairly, significant. And this could be in the form of not having a good relationship with their bodies, particularly where sexual assault and rape is concerned, not being able to feel confident, not having an adequate self-esteem that is important to adapt to one's, environment, struggling with a lot of feelings of inadequacy, perhaps also dealing with a lot of emotional trauma, which is, again, of various kinds. It could just be anxiety. For a lot of people, it could be depression. For many others, it could just be a lot of aches and pains, physical discomfort, not being able to sleep too well, eat too well, and so on. what is significant is also the lasting consequences on relationships that they have. So they're not able to trust people, they're not able to be in, satisfying relationships. They don't feel secure in relationships. So I could go on and on. So basically what I'm trying to convey is that there could be consequences acutely that a woman has following traumatic events and very long-term lasting consequences of trauma.
Just a follow-up there in the context of, because we are really framing this in the context of the marriage. So in the context of the marriage, when people come to you, what is their main ask? Because when we spoke, you did mention they just want the abuse to stop and they want a resolution, which sounds like it's a simple thing to fix, but is in reality quite complex. So typically, what is the ask that they have got? Mm-hmm. And secondly, how ready are they to go for legal remedy in such situations? And then I'll bring the lawyers in.
Sure. I think very happy to have two lawyers to defend the legal stance, because commonly what we confront is also, what are my options? But most importantly, like I was telling Mr. Ravi when we spoke informally, is that women definitely want the abuse to stop. So they come to us hoping that we will make this abuse stop. We will give them some emotional support that they need because they're really going through some challenging times. A lot of women, sadly, don't want legal options, although we think it's our responsibility to make them aware that they do have some legal options. A lot of them say that they're quite happy to continue in the relationship as long as abuse stop. So you tell me how to make the abuse stop. You tell me how I can be treated with respect in this relationship. Please talk to my husband. Please talk to my partner. Please see what you can do to change his views about relationships, how I need to be treated in the relationship, how I can feel respected and valued.
Thank you. Aarti, coming to you, while I was reading up on this and searching, and thank you, Sneha, for some amazing links you sent across to me. I just realized that it has its origins as women being treated as property. In fact, this phrase I saw, I think Hayes or someone who says, women as chattel. I mean, that's really how it was. And it's only in the last 100-odd years that whole definition of taking the woman as property out has really happened. So give us a sense in jurisprudence and law, because we have adopted British law, in terms of how did this start, this whole concept of the place of a woman in a marriage, and how has it evolved in the Indian context over the years, which finally resulted even in the J.S. Verma committee saying that, we need to do something about it in 2013.
So that's a fairly sort of, it's a complex trajectory because right until 2003, if I'm not mistaken, the offense was not, marital rape was not an offense even in the UK. Okay. They only removed their exception when they codified the Sexual Offences Act in 2003, which is actually very, very recent. So essentially what we did was to just lift the way the Indian Penal Code was formulated was pretty much a lift in terms of classification of offences. Actually, the marital rape exception is not a contradiction in the internal logic of the Indian Penal Code until recently, till your adultery was decriminalized as an offense. But the adultery decriminalization is a very interesting one. The offense of adultery before the Supreme Court decriminalized it was an offense against the married man whose wife someone might be having a relationship with. So a wife could never complain of adultery if her husband was having a relationship with another woman, because the offense is against the husband, because the wife is the property of that particular husband and another man is in some way encroached upon this property. So within the internal logic of the Indian Penal Code, it's not a strange exception to see. That's one thing.
Except that it assumes that in a marriage union they are one and they are not independent entities.
Absolutely. And that because you have you have given your consent to the marriage, you have also automatically given consent in perpetuity at any time, at any place, to sexual intercourse. That's the assumption, that's the internal logic of why that. The exception is actually a wife not being under the age of 15 years.
Right.
So if the wife is under the age of 15 years, it amounts to an offense both in the IPC and then under more newly enacted provisions. Now, it is also not, the logic is also not terribly misplaced if you look at the way marriage statutes are constructed. So almost all marriage statutes have provisions that where you can call upon a spouse, whether husband or wife, who has left you, to return to cohabiting with you,
which is the restoration of conjugal rights.
Which is the restitution of conjugal rights provision. Except that the consequences of restitution of conjugal rights are very different when a husband is asking a court to compel cohabitation, and when a wife is compelling a husband to resume a marital cohabitation in a home. And actually this way back in the 80s, a very, very progressive judge of the Andhra Pradesh High Court actually said that restitution of conjugal rights is much more unfair to women and to wives, because when you compel a wife to return, you also compel her in some way, and she may be forced with unwanted pregnancies, sexual assault. So he actually strikes down as unconstitutional the provision of restitution of conjugal rights. Unfortunately, a few months later, the Madras High Court holds differently and says there's nothing wrong with the provision, because on the face of it, it's equal. Right. A wife can compel a husband to come back in as much as a husband can wife. This goes up to the Supreme Court of India because you have two conflicting High Court decisions, and the Supreme Court of India holds that there is no problem with restitution of conjugal rights.
So that stays even today? That
stays even today. It exists even today. As far as I know, there is no challenge pending in any High Court on that particular provision. But now that you've had a significant shift in jurisprudence of privacy post the Puttaswamy judgments, you may have now an inroad into reopening that question of bodily autonomy, privacy, and restitution of conjugal rights. I suppose we're all waiting for that right moment, that right judge, that right bench that we all do as lawyers to see where we can take it. But the internal logic of it, that specifically in the context of marriage, there are certain marital obligations, and this is actually quite a global thing.
So it's an implied consent at the time of marriage.
Yeah, at all times, forever and in perpetuity. So,
but I have just a quick follow-up there. Earlier, certain kinds of sex acts were not there. It was also considered a crime, which then said it's okay. It covers all sexual acts, was the change. So that's an instance of adding things to the IPC and saying...
No, it's actually removing things to the IPC. Okay. Because when you decriminalized Section 377 still exists on the statute book.
Yes.
The provision still exists because, and this is the biggest problem with it, it exists on the statute book because you have no other provision to deal with sexual assault or violence either on men or on trans bodies. The 375 rape is very clear. The victim of that offense is always and only a woman. So you need something left.
For the other.
Yeah, so what they did is they kept 377 on the statute book, and they just said that consensual activity shall not fall within the purview of 377. Okay. So 377 still stays very much as it is.
It's just decriminalized.
It's just read down to not include consensual sexual acts.
Sneha, you have done a lot of work really around sexual violence and women, etc. What's your take on the current debate in terms of where we are from your research and studies? And it's a larger one around sexual violence across all categories. And if you could focus it in the context of marriage, what has your research found? At this stage, I just want to bring in, and from a society angle, in fact, I was really depressed when I saw, the Pew survey with 30,000 respondents put out a result last week. And 90% of Indian women say, strongly agree or agree to the statement that they must follow their husband. So that is a figure as of 1 week earlier. That, of course, that report has some progressive things elsewhere, saying that women can be, good at finance and women can be in parliament or whatever. But this particular statistic was very glaring in terms of, and I think Sneha mentioned it, and I think you'll mention it, that 70% of women in another study said it's okay to be beaten once in a way. Sneha?
Yeah, sure. Thanks a lot for inviting me to take part in this discussion, Ravi. I think based on my research, there are a lot of things. This is a very complicated issue. I feel like it's very difficult to sort of think in terms of frame one. But sexual violence, actually violence against women, and I guess male violence against women is a pervasive characteristic of not just Indian society, but all societies. It is something that is ongoing, it is something that is historical, and it is something that is sort of an outcome of existing social relations and social structures. So the study that I think I was referring to is the National Family Health Survey, which is a survey that is conducted by the Government of India. And in that, and it's very shocking, last year in NHFS 5, it was found that more than 75% of women, particularly in Karnataka, Andhra Pradesh and Telangana, with 77%, 84%, 82% respectively, said it was all right for husbands to beat their wives. Women said it was all right for husbands to beat their wives for a variety of reasons, such as neglecting house or their children, disrespecting in-laws, including refusing sex. So these were all perceptions where women themselves were like, yeah, it's all right. It's all right for the husband to hit the wife because these are, your roles. So to me, the question of violence against women, male violence against women has to be understood in two contexts. Often the law, and as Aarti pointed out rightly, that this is the internal logics of the criminal law recognizes violence against women where it's out of that structure, whether it's stranger rape or stranger violence, somebody who is not the husband, somebody who is not the family member. So we see that there is an inherited legal infrastructure that is rooted in essentially the idea of perpetual hegemony. And this is not alien, this is not just British law, this is also Hindu law. Like Manusmriti talks about perpetual hegemony, where women cannot be trusted with independence, autonomy. So when you're a young girl, the father controls your life. When you're, when you're in your youth, the husband controls it. When you're old, your son controls it. So we see that marriage, strangely, across cultures, always emerged in the context of seeing women as property. So women as being bartered between communities. And you see, I remember in our women in law class, a professor said, we talked about Kanya Danam, and she said, what can you give as Danam? The concept of Danam is something that you own. And so it's very important for us to remember that women as human, or women being recognized as human beings, is a very recent historical fact. So what I think is we are grappling with legacies of patriarchal logic that has seen women as property. So our laws continue to, see and treat women as property in some ways, even though there is a lot of change today. And I think when we engage with the law, we see that there is not a lot of thinking about what do you do when the perpetrator of violence is a loved one? What do you do when the so because the questions and criminal punishment, in my opinion, becomes like hardly an answer. Because if you're somebody who is, how many people will you file cases against? And also everybody, I think Aarti will probably be better to speak about what criminal justice system itself is designed for, what it does for a woman to file a complaint about, and how much of, and I completely, I resonate with that. I think if you're somebody who's experiencing abuse, you want to move on with your life. You want to leave that behind. You want to live your life in a better way. But what I would like to talk about is that even though criminal law is inherited, whatever these legacies, law can also be a tool for changing social mores. And to me, the question of criminalizing or removing the exemption that exists for marital rape, irrespective of whether tomorrow it solves, I don't believe that women, it'll start completely eradicate intimate partner violence, that women experience. But at the same time, it's also a moral stand. It's a country that sort of says that, okay, we no longer believe or treat women in this particular way, which is one. But two, what is also important is we have to keep in mind, where is the infrastructure that actually is designed to allow women to leave abusive homes? Because I think it's very important that for a lot of women, not just in India but across the world, there are material conditions that keep women in marriage. So it's economic dependency, it is social dependency. There is such a strong taboo. And we also have to realize that we are having a conversation about marital rape in a country where divorce is so stigmatized. The latest data that I found is less than 1.1% of the population actually opt for divorce. So what is the status of women? And I also want to talk about marital rape in the context of domestic violence, because I think the disproportionate scrutiny on sexual violence also takes away the scrutiny over the horrific nature of domestic violence, which includes physical abuse, emotional abuse, psychological abuse, even financial abuse, which then means that you have an entire population in the country that is systematically, ideologically brainwashed into thinking that these are your roles, and you have to be disciplined and punished if a woman fails her, mandated social role. So I think,
Thanks.
yeah.
So Sneha, basically what you're saying, if I get you right, are two really big points there. One, you're essentially saying that unless there's a social infrastructure and an attitudinal change where such women can be accepted, it is going to be a challenge, because the law exemption is not going to fix it per se. I think that's my main takeaway actually in terms of what you're saying. And unless we have that, but anyway, it's good to go out and remove this exemption so that the judiciary puts pressure on changing the social mores. The politicians are not doing anything because the public is not where it is. It's not an issue that is going to be popular on the ground, because the conservatives currently are got a higher proportion of people, like the 70% that you mentioned. So Veena, in the context of this, the women that you meet, do they articulate at the anecdotal individual level, do you get the same sense of what we're getting from the larger statistics, that it is okay to be beaten, I must have done something wrong? Is there some kind of a rationalization that people get into? And somehow help me solve this.
Absolutely. I think the National Family Health Survey that Sneha spoke about to a great extent represents reality that we see in the clinic. We do have a lot of women perpetuating patriarchy as we have men perpetuating patriarchy. So a lot of these women think that they deserve it. They've done something wrong to deserve this, and it's okay, they have to put up with it. They have to improve themselves, so they have to probably cook on time, they have to cook better, they have to cook, food that is more tasty or more nutritious, whatnot. I mean, there's no end to justifying this, and I think that's what we see. Aarti mentioned a very important point about consent.
Yeah.
So that again has been deeply inculcated in women, that it is she who consented for the marriage, and so she should be okay with forced sex as well. So they don't look at consent as something that should not be a one-time thing.
Right. And it's a dynamic
daily thing. You could have consented to it, you can change your mind now. You can consent for certain things, but you cannot. It's okay to not consent for certain other things, and that's perfectly all right. But the women think that that's not okay.
Yeah. So as part of that social infrastructure, even that change needs to be brought in terms of their rights. So moving on, I just want to try and go through the 2 points of view. The people who believe that we need to keep it, the conservative view, or the Men's Welfare Association, which body is fighting for that, and the group which says that it needs to go. I get a sense, I mean, I could be wrong, this room might feel it needs to go, but it's not the answer. And we'll come to that at the end. So let's now put on the other hat and say why it should remain. And I was just trying to do some, and I'd like you to react to some of the points that I read as to why it should stay in terms of the arguments in court. So one, they say, if you remove it, it is akin to creating a new law, and that is the remit of Parliament. Therefore, the judiciary, the Delhi High Court, cannot do it. So that's a technical point as to who should do it. Of course, there's a counter which says it's really not removing a law. We can get into that. The second point that is being made is the phrase that I saw is the parade of horribles. It could cause a thing in terms of misuse, then it also could be problematic with the gender neutral thing which you mentioned about the 377. And therefore, there is this vindictive wife, innocent husband syndrome also out there. So that's the phrase that people have used. How do you prove it? It's finally so private, it's between two people, the burden of proof, and you can walk us through what happens in a court case in terms of thing. And finally, they of course say, you can always get some of these things done under provisions of Domestic Violence or Dowry Act and use those. In fact, even in divorce cases, the lawyers now advise just put in those things because it'll help your divorce case. And lastly, I'll just conclude with what Sumitra Mahajan, I'm just paraphrasing what she said in Lok Sabha when this bill came up, the Speaker of the Lok Sabha. People these days get divorced over insignificant issues. Marital rape should not be made into a criminal offense. Things like this should be sorted out within the family or by counseling. There is no need for a law. All three of you, I've just thrown the whole grab bag of arguments being used. And apparently there's something called privacy strategy. I reread it 3 times, didn't understand what that point was. So if you can also amplify on that, Aarti.
I don't think that the removal of the exemption, it's a very unique situation. The removal of the exemption will make it an offense. There's no doubt about that. You remove the exemption, it'll become an offense under and it'll be a criminal offense. In the same way that 375 is an offense for any other type of rape. So while it will be the creation of an offense, it is not legislating. The Delhi High Court would not be guilty of legislating a new offense. Right now, what they are testing is whether the exemption in and of itself is constitutionally valid. That is what they're doing. They're testing that particular exemption against the larger scheme of the Constitution in terms of equality, life, etc. So I'm not sure that, I think that the Delhi High Court would be well within its jurisdiction to hear it and decide one way or the other.
Issue. It can be done in the courts.
Absolutely. The problem is this, and I think that it is not as simple as removing the exemption. And I'm saying it's not as simple because you have several other statutes that intersect with the IPC and the Code of Criminal Procedure. If you look at the Protection of Children from Sexual Offences Act, and that there a child is defined as someone below the age of 18 years, whether or not you are married to a perpetrator, you will be guilty of a statutory offense of rape or sexual assault or any offense that the Protection of Children from Sexual Offences Act is. So actually the exemption already does not exist for a wife under the age of 18 years because it's an offense under a special statute. Right. So already you're conceding, the legislature has conceded that there is something that is happening to children, and a child is defined as someone being under the age of 18, whereas the exception in the Indian Penal Code is 15. So we're already seeing some tremendous gray area situation that is emerging ever since you have legislated the Protection of Children from Sexual Offences Act.
Yes.
You also have the Child Marriage Restraint Act, which makes it an offense to marry a child. Again, child is defined as 18 under Child Marriage Restraint Act. Karnataka has made any child marriage that is solemnized void, ab initio. On the face of it, that marriage is void. It's a Karnataka specific amendment. I believe a few other states have a similar amendment. So that marriage in itself is void. Therefore, it will be an offense, in my view, under 375 as well as the Protection of Children from Sexual Offences Act. So we are conceding that there are many relationships that are considered marriages by the people who are in them, which already have a marital rape problem that is going there. That's one thing. So it is not, I don't think that it's as simple as saying we'll remove the exemption. I think you have to relook at the entire scheme of sexual violence against all populations. You can't, this kind of
Marital status.
this piecemeal sort of, we will remove this, we will include this, actually then creates these varying things. IPC says the wife should be under 15 years. POCSO is saying, no, it's 18 years. So, I mean, what is the difference then between a wife under POCSO and a wife under IPC? Surely it's the same person that we are speaking of. But nevertheless, POCSO still makes it an offense, which is good. At the same time, you have the Domestic Violence Act. It's a civil statute that is run in a traditionally criminal court, but the reliefs that you're getting under the Domestic Violence Act are things like are injunctions or restraining orders or compensation, etc., where sexual violence is clearly articulated as one of the forms of violence, of domestic violence, as a separate category. So I think there is a certain concession that is happening by the legislature itself, that there is sexual violence within the context of a marriage. This exists.
Right.
So there is, I don't think we're anymore dealing with, does the legislature believe that there is such violence? I think it squarely says there is, right? It now has to, I think, get into the business of trying to figure out exactly what you pointed to. When we speak of sexual violence or any type of violence within the four corners of a house, we enter a very, very, very tricky territory. Now, with criminal statutes, if you're saying that I want to, as the state, because the state is the prosecuting agency in any criminal offense, as a state, I want the power to go in and make an arrest instantly, because that is what I'm supposed to do as an investigating agency. If someone comes to me and says, if a woman or any person comes to me and says that I have been sexually assaulted or raped, then you are entering a very complex zone. This is the zone that you are entering. The test of a robust criminal justice system has to be that you are defended and you have a defense that can and will be mounted in a court of law. So whoever that accused might be, and in this case it will be husbands, as a criminal defense lawyer, my mind is going to, what is the defense? Now, that defense is the same defense that we have irrespective of whether it's a marital question of rape or otherwise, except that we are functioning with much less. We are functioning with much less on both sides. As a victim of the violence, standard things that we might use, we may not be able to use, because it would be, if you say you're relying on, say, DNA evidence is actually not very useful to you in a marital rape situation, because it could well be an entirely consensual situation. That is one thing. Which means that you're relying very heavily on the testimony of the prosecutrix, that is of the victim. And that has been such a highly contested area of what happens when you have no other corroborating evidence, but you have a prosecutrix who, under very complex cross-examination, is sticking to a very clear standard narrative of this is what has happened to me. Now, currently in rape cases, the unwavering and steady testimony of a prosecutrix is enough for a judge to convict, even if he or she is not able to see any other evidence, any other corroborating evidence, quote unquote. So the question is, how do you create that robustness where victims are treated with respect and honesty, and accused are given a full ability to defend themselves against a criminal charge? Because remember...
So the standard is beyond reasonable doubt?
Always. It will always be beyond reasonable doubt as far as a criminal trial is concerned for any offense, whether it is rape, theft, UAP, whatever it might be. That is the standard. Now that's a very, very high standard when you look at an offense of this nature. So the difficulty, I think, is the nature of how we prosecute these cases and how the Criminal Procedure Code and the Evidence Act are structured. And if we create this to be an offense, my concern is actually, I don't think my concern is a misuse in the way that the men's rights organizations are saying, that there'll be hundreds of wives suddenly rushing into police stations and saying, I've been raped, and use it in collateral proceedings of divorce or custody or whatever it might be. I'm not saying that cannot happen. It happens even now to some extent. So I'm not going to rule out the possibility of misuse. I can't. That would not, every criminal provision is misused to some extent. But my worry is if it's removed as an exception in this case that is ongoing without thinking through the ramifications of all these other things, then I fear what happens to it is what has happened already to the provision of 498A, where the judiciary has watered down to such an extent that provision which allows women to complain of cruelty. And it has already been watered down so much by the judiciary itself that you can lodge an FIR under 498A, but no one is going to get arrested because of the guidelines that various courts have laid down to the investigating agency of don't make an arrest until you comply with certain things.
Under the cruelty clause.
Absolutely. By which time someone has secured anticipatory bail. Anticipatory bail is given for the asking in cruelty offenses. We argue for less than a minute to get anticipatory bail in a 498A case or a dowry prohibition case. It's just given because by the time the police are going through that checklist of what the Supreme Court has laid down, gives us more than enough time to obtain it. And this is the judiciary's doing. The law itself is quite clear. It's a non-bailable, cognizable offense. If an FIR is lodged prior to the Supreme Court guidelines, an arrest would ordinarily have been made, right? So I'm actually concerned that we are going to be in a situation where an offense gets created, but we haven't thought through all the supporting things around it that enable it to be an effective prosecution for the victim. And at the same time, what is this? How do you defend an accused in a situation like this? Because that is the true test of a fair and robust criminal justice system. It can't be that we're putting accused into a position where it's either very, very difficult to defend or it is incredibly easy to defend on either side of that spectrum. So there must be some very careful thinking about this.
So I got it. So Sneha, just to take off from there and your overall influence. So if I hear you right, Aarti, basically what you're saying is a deletion, here subtraction, those piecemeal approach needs to go. We need a comprehensive look and see the interconnectedness and fix it. I don't know whether anybody is even applying their mind to that overall kind of.
Not in this. I don't think in this case.
In this case, no. This case is just related to that. Yeah. So, what would be the contours of that, if I can call it the safe harbor, or the thing by which we can land safely on a pretty complex issue? Sneha, any thoughts?
Yeah, no, actually, I was listening to Aarti. One thing, I think one of the things I sort of just wanted to add as context is, I think whatever laws in India that we have that have specifically been designed for women's protection, whether it's 498A or dowry deaths, etc., did not really come because the legislature sat up and decided, okay, women's plight is so bad, let's do something about it. No, they came after widespread protests and women's movements in this country. And that also happened because I think when I was in law school and I was reading some of the history of India, more than 10,000 women were getting burnt alive every year. These were just statistics. Dowry deaths, it's like being burnt alive was literally, there were so many cases that we have the honor of creating a specific criminal, offense of that. And I just wanted to add one other thing. So the thing is, forced sex in marriage is already a crime. This is not just, so marital rape exemption is basically under cruelty and other provisions, it can already be prosecuted. So this is not creating a new offense. It's just removing an exemption which says if you fulfill all criteria of what constitutes rape, it should not exempt married men from that. So to me, what is profoundly it's disorienting is that the fact that men routinely rape their wives within a marriage is normal, to a point where we are having conversations about what is the relationship between men and women in this society where these levels of stark and horrific violence are normalized.
Right.
And so to me, there are two levels of that question. One is, in very practical and material terms, where do women go? So if, for instance, and I don't want to touch criminal proceedings, primarily because if you look at any statistics of existing other rape statistics, so when you look closely towards the cases that actually go to the court,
And the prosecution percentage, win percentage, or whatever you want.
even win percentage. So Public Secrets of Law is a book by Pratiksha Bakshi, where she actually looked at what are these cases that actually go to the court. You would be shocked to find out that the cases that actually go to the court are consensual sexual relationships, where the parents of the girl are unhappy, whether it's an intercaste marriage, it's an interreligious marriage, where there is a minor who is 17 and there's like similar age group. So you have rape cases where the woman is standing on the other side and saying, that's my husband, but the family wants to put pressure on breaking the marriage. So existing laws are not being used for women to protect women. So any chance of a misuse of this is ridiculous because there is no data that supports it. If you look closely at whatever, you see the horrific record of implementation, which brings me back to the question of safe harbor, right? So to me, this question does not lie in law in the way that it's imagined right now, because I think there is no imagination of actually creating a criminal justice system that actually works for women, number one. And number two, if criminal justice is actually the only modality of justice. So to me, the problem also lies in the Indian state refusing to actually bring about any measure of social equality. Because the reason why legislature after legislature, they don't want to touch marital rape is because this foundation of an extremely brutal and unequal system is beneficial. It's beneficial for capitalism. It's beneficial for the economy because there is unpaid labor that is happening at home, which is, you want the system to continue. But the problem, I think when it comes to creating safe harbor, requires that as a society, we acknowledge women's humanity and to say that everybody deserves dignity in order to be able to live the best fulfilled lives. But in our country, we prize family over the woman's life and dignity. So, in fact, Cuba is actually a country I was looking up, because when I was thinking about it, Cuba is after the economic revolution, there was actually a very concerted effort made in Cuba for women's freedom and women's equality. So in 1961, first daycare centers were opened because they recognized that women's subjugation had very material underpinnings. The lack of childcare infrastructure prevented women from entering the workforce. The lack of any kind of, avenues for dignified work that allowed women to work for themselves and earn their living. And you wouldn't believe, Cuba's family code actually put it in law where it said men and women have to share domestic work equally. Now, can you implement it? Maybe not. But the point is, there was a recognition that the home was a space where domestic responsibilities have to be shared. And finally, I think, to me, then the question then becomes they also started free education programs. So by the time it was 1960s, half of all medical students in 1960s were women.
Right.
So 1970, 55% of all school-going students were women and girls. So very clearly, social infrastructure were free transport for women, safe housing for women,
right,
mixed-use planning. Because what often a woman needs in order to escape an abusive home is a place where she can take her children, work a dignified living, and be able to access, where school is close by, work is close by, housing is close by. And she's able to sort of do all of these without great cost, without depending on the family, without depending on the very networks of,
right,
that oppress her. And lastly, what I just wanted to add is that this is also a question of why is marriage given the centrality that it is in society?
Yes.
What are the ways in which law sanctifies marriage, so much so that marriage is the only path? And why is it that marriage is sort of, you see that, tax benefits.
Everywhere.
Everywhere. So I think it's important for us to question that in terms of why is marriage the only way for people to be able to relate to each other, to enter into intimate partnerships? And why is marriage where, every report after report talks about these horrifying attitudes we are continuing to trying to reform a unreformable institution.
Right.
So I think with those I would.
So and also on marriage, even if you see the benefits that accrue, everything is through the filter of the marriage status.
Yeah.
Even the pensions, it
Yeah.
flows to the son, doesn't go to the daughter. Various kinds of
Yeah.
challenges are there if she's married.
Yeah.
Now, just in closing, we have another 5-7 minutes. We spoke about retaining it, but here's my counter. The other thing, I just saw the countries that have scrapped the MRE, removed the MRE. England, France, Belgium, South Korea, and Nepal, a predominantly Hindu country. They've also repealed the MRE clause. And the case really being made is it's against Article 14, I think equality, non-discrimination, 15I, dignity, 23 or whatever. I didn't go to a law school, so I might have got some of these numbers wrong. 20.
And you don't know anything else, you must
I say Article 21, dignity, after that you'll be covered. So, and if I see Justice Sheikh there, they make talk. Let's see what the final judgment says. As one context, he said, does not matter if it's a wife or a live-in partner, a woman is a woman, and no means no. So basically bringing the angle of consent. I'm just as a statement that he made in court. She's of course cynically smiling, but the question therefore really is, and with the Puttaswamy judgment, in a sense that time has come. I understand that removing this may not fix it, but a time has come to at least remove the exemption, however badly it works, while we work on the social infrastructure, that comprehensive, interconnected thing. Why should this stay till we fix? That is my last question, really. Can this be removed and keep fixing the others versus fix the others and then remove the exemption?
If I can answer, I think we should remove it because it's patently unconstitutional. It's unconstitutional. According to the Constitution, it is absolutely, frankly, it's disgusting. I think that any kind of social relationship that is given legal sanctity, where, I'm sorry if this is like controversial to say, but the only place where you deny a recognition to a intimate violation of another human's body is in the context where autonomy doesn't exist. It's a form of sexual slavery.
Right.
And so is that the kind of exemption we want to retain in a civilized country with a constitution that enshrines equality, freedom, and,
And why should the state interfere in this whole female sexual autonomy and agency?
And in order to reassert female sexual autonomy is, to me, one of the most basic questions. The fact of the matter is whether this will solve the problem is another matter.
Yes.
But we have to remove this because it's patently unconstitutional.
Right.
So that's...
Veena, any thoughts?
Yes.
I'm sorry, the lawyers took over. You know how it is with the lawyers.
Yeah, I just want to agree with the lawyer and say that marital rape should be criminalized because it's very counterintuitive to say rape is wrong, but marital rape is okay. And when we know that rape is at the far end of the continuum of severe violence, and we know that it has very far-reaching consequences, significant ramifications on, mental health and all of that. Also, to probably, say that laws can be misused. We know that a lot of laws are being misused, and what proportion are really misusing these laws versus what proportion will really benefit from these laws. I think some of those need to be looked into, and like you rightly pointed out, we need to really thrash out some of the inconsistencies about the age. In one place it says 18 years, in another place
15.
it says 15. Gender, that rape can also happen to men. We see a lot of violence happening to men, so it's not that a man is always seen as the accused. It's important to look at the consent process very carefully, to say that consent is not a one-time thing and people can change their mind, or consent needs to be fragmented and understood. What are they really consenting to and what are they not consenting to? I guess the most challenging point for me is preparing a woman, or a man for that matter, to contest this in court, because the process can be very, very disconcerting. The process can be re-traumatizing,
Yes.
because constantly a woman has to keep re-narrating the
Reliving
same, trauma, repeating it over and over again to many different people. So I guess as a psychologist, I would say those processes really need to be looked into to see how we can make this whole process of entering the court, contesting this in a court, a little more sensitive.
Sensitive. Any last words, Aarti? We're just about to close.
There's no doubt about it. I don't think one can possibly, in a civilized situation, say that we keep the exemption. So it must go. I do, however, think that if we don't start working the very serious logic of getting sexual education in at younger years of adolescence and getting young girls and boys. I mean, this is not about educating just girls. But if we are not going to work this backwards, you can remove an exemption. You can do some great stuff with, trying to put in place some safeguards. You can do all of these things, and it will mean nothing, because you're only coming to the law when something has gone terribly wrong. If you're willing to work this backwards and you get younger men and younger boys to understand how they treat partners, whether wives or girlfriends or partners of any kind, then I think you might be seeing a shift that is far more productive than if we're going to just be tweaking these things a little bit here and there.
Point well taken. In fact, the late J.S. Verma said in 2013, that committee report, remove the exemption, but bring in the attitudinal changes. And all the points that you made was the essential thing that he mentioned. Thank you, fellow panelists, for doing this. You have a question, please.
So this is to Veena, really. You're saying that you meet a lot of such cases. Can you give us one case study where you resolved it satisfactorily, and some tips of how you help that family come together without it going maybe to the lawyers?
We're quite happy if it doesn't.
And most of them tell Veena, we don't want to go to the lawyers. In fact, they actually say that.
I'm an urban researcher. So
And they also...
Okay, I think that's a very, very important question. We do have a lot of success stories, but this is also when violence tends to be mild. I hate to say mild violence and more severe violence, because all violence is known to, impact a person. But we still sometimes make that distinction to say that in certain cases of physical violence where there is no coercion really of a sexual nature, emotional violence, some controlling behaviors, where the man also is a little insightful, is not very proud to be doing all of this, recognizes that there is a problem, is willing to seek help, comes very regularly for help for couples therapy and so on. We have been able to achieve resolution. They are in marriages which are very respectful of each other. But in the context of sexual violence, and also very severe sexual violence like rape, sexual assault, and so on, we've not had couples therapy recommended, because sometimes the danger of couples therapy is also that violence can escalate against the woman, and we would be also very concerned to put that woman in that position. So in most severe cases of violence, we don't try to discuss all of this very openly with the family, and very many times the lady is not comfortable sharing all of this. So in individual therapy contact, they may be able to tell us all of this, but not in the presence of family members and the spouse. So we constantly watch against violence escalating by involving family members. We try to prepare the lady with, possible consequences. We see if she's ready for it. We call the spouse in. We sort of talk about all other issues and see how he's taking it, whether he's too defensive, whether his body language indicates aggression, and so on, and then gently broach it. But success rates, definitely mild, moderate amounts of violence we've seen, but not in cases of very severe violence.
Thank you so much. And thank you very much.